Hi everyone, I'm Natalie Alexander. Welcome to The Commons, our space here at the UN Library and Archives, Geneva, designed to explore questions on multilateralism. This is our history series, where we get to dive into different aspects of the history of multilateralism, together with historians and experts, and also take a look at some of the incredible archival documents held here at the Library and Archives. This episode, we're exploring multilateral efforts to fight slavery. It's often considered a dark part of our past and linked to the transatlantic slave trade. And yet, according to the latest Global Estimates report on modern slavery, 50 million people are living in modern slavery. That's about 1 in every 160 people in the world. Ending modern slavery is a part of the UN's Agenda 2030 and the Sustainable Development Goals, particularly the target of SDG 8 on eradicating forced labor, modern slavery, and human trafficking. What role has multilateral cooperation played in achieving this objective? There's a lot to discover from our recent history, and we recently marked the 70th anniversary of the entry into force of the 1953 Protocol to the Slavery Convention. And this year, in 2024, will mark the 10th anniversary to the Protocol on Forced Labor. What were the challenges faced at the time of the League of Nations, and what have we achieved since then through the United Nations? As we look to the SDGs today, how do they continue this work to fight slavery? We have a great lineup of speakers who are going to answer these questions for us today, and I'm very happy to introduce them to you now. Joining us from Australia is Professor Jean Allain. He's Professor of International Law at the Monash University in Melbourne. Professor Allain, thank you so much for joining us today.
It's my pleasure, Natalie. I'm glad to be here.
Great to see you. And then we have here with us in Geneva, Alix Nasri, who's technical specialist on forced labor at the International Labour Organization, or the ILO. Alix, welcome and thank you for being here.
Thank you very much for having me, Natalie.
It's a pleasure. And also joining us here, especially for the second half of the conversation, we have two master's students who are studying their Master in International Development Studies, and they also did a research project here with us at the Library and Archives. Yan Zhu is specializing in migration issues, and Marie Oy is specializing in gender, race, and diversity. It's lovely to see you both again. Welcome and thanks for being here.
Thank you for welcoming us.
Of course.
Thank you for having us.
So let's dive straight in and explore some milestones in multilateral efforts to fight slavery. First, to you, Jean. The first international agreements to abolish slavery were adopted in the 19th century. But if we look at multilateral efforts to fight modern slavery today, these can be traced back to the League of Nations. And one particular milestone is the 1926 Slavery Convention. This was not only significant because it was the first international instrument adopted under the auspices of an international organization, but it also contained, interestingly, the first definition of slavery still in use today. So can you tell us about the complexity of defining slavery and the definition in the convention?
Thank you for that, Natalie. The League of Nations is fundamental. The work that it did was fundamental to understanding slavery, both as it evolves and its considerations evolve within the League of Nations and the United Nations, and today as well. You're right to say that the definition established in 1926 still is in play today. It was repeated in a subsequent, a 1956 UN supplementary convention, repeated word for word, and was also adopted as the crime of enslavement before the International Criminal Court in 1998. So very much relevant today. The complexities stem from, in part, I've come to call it the 20th century problem, that for much of the 20th century, that we could say that slavery did not exist. It didn't exist in law because states had an obligation to repeal any laws that allowed for slavery. Right? So we were, if you wish, getting rid of, and at the tail end of getting rid of legal slavery. And so to abolish was to repeal those laws that allowed for slavery. But what that meant was that by abolishing all the laws, by repealing all the laws that allowed for slavery, then the understanding of slavery being legal ownership, there were no laws that prohibited slavery. As a result, by law, we had wiped away the very notion of slavery. It couldn't exist because you couldn't be held responsible for slavery because there was no crime, let's say, of slavery. So what this meant was, and that's because it was tied to this legal ownership. And because legal ownership did not exist anywhere in the world, then you couldn't be enslaved. So this raised very interesting issues. But what it meant more than anything, especially in the early 20th century and through the UN, was that this notion of slavery could be used for other social ills. And most obviously was in regard to what we call today human trafficking. But in the early 1900s, before the League of Nations, you had two legal instruments, European really, legal instruments, that dealt with the white slave traffic. And these instruments were really around international prostitution. But they take this visceral language of slavery and used it. And so we've seen it in various instances. And even today, we talk about modern slavery as a type of an umbrella term, which can include things like forced labor, servitude, trafficking, child exploitation, etc. I come at it from an international law perspective. So when I'm talking about slavery, I'm talking about specifically slavery, not this umbrella term, unless I'm speaking of modern slavery. So you had this visceral notion of slavery, and people were trying to attach things to it. In 1930, there was an international commission that looked into what was meant to be slavery in Liberia. It was an international commission. It would ordinarily have fallen under the League of Nations mantle, but the United States was the one that was pushing it. There are historical ties between the United States and Liberia. So an international commission was formed to look into slavery and actually to apply the 1926 convention. But they didn't find it. And so they rewrote their terms of reference and rewrote their understanding of slavery to include forced labor. And then they found that there was, in fact, violations. So we see this kind of use of the language. In 1956, I've already mentioned the Supplementary Convention. That Supplementary Convention sought to focus on, and from the League of Nations onwards, focused on servitude. But for reasons of not wanting to abolish certain servitudes, the former Soviet Union argued that we should change the term servitude, although it was fixed since the early days of the League of Nations. And so what they came up with instead of servitude was this notion of institutions and practices similar to slavery. So again, we're moving away from slavery as a legal concept to an umbrella term that captures this now. What we used to call servitude are now practices, institutions and practices similar to slavery. If we fast forward again until 1966, you have an attempt by newly independent states to attach slavery to apartheid and to colonialism. It fails, but what emerges is a new, at least a term of art, if not a term of law, a term of art called practices, slavery-like practices. So the complexity of the notion of slavery is that you've got all these things that are being called slavery, so that the leading historian of the 20th century, Suzanne Myers, speaks about the notion of slavery as having been used in so many different ways that it became meaningless. And that, in a sense, is where we were in the complexity in the 20th century, that slavery really didn't mean anything because it meant everything.
Yeah.
Now, that was one dynamic. And the other dynamic was that during the 20th century, that slavery, although the core, what we knew and understand as slavery, was kind of lost, but the core around it was being protected. The norm, if you want, was being protected. Layers of protection. So the one that's most familiar is that slavery became an international crime, right? And so there's some added protection. It also was made non-derogable. That is to say that even in times of emergency, you can't suspend the right not to be enslaved. And then there are more technical issues around, for instance, invalidation of legal treaties and this notion of preemptory norms, a jus cogens norm, and obligations ergonomous. These are technical terms, but really consider it as extra layers of protection around this concept of slavery. But the core itself was lost and was recognized mostly by states by not really paying attention at all because you couldn't legally own somebody. Now, that starts to change, and in 2016, you have the Inter-America Court of Human Rights declaring that, in fact, it's not only about legal slavery, but de facto slavery. And there is some of the work that I developed in looking at the travaux préparatoires, the legislative history of the slavery conventions, both the 1926 and 1956, and looking specifically at the definition. So, Natalie, if you'll allow me, I'll just talk a little bit about the definition itself and how it's being applied today. Yeah.
Sure.
So the definition, word for word, is this, right? So this is the 1926 definition, which is repeated in 56 and again in the Statute of the International Criminal Court. And that is, slavery is the status or condition of a person over whom any or all of the powers attaching to the right of ownership are exercised. Very wordy. And what you hear is ownership. So slavery is about ownership, but not quite. So the first element of that, slavery is the status or condition. Well, status is a legal concept. What is your marital status, for instance? What is your immigration status? It's a legal status. But a condition is a means of being. A doctor asks you, how is your condition? Right? So in that context, it's a distinction between the legal, right, the status, and de facto. What is, in fact, how are you feeling, your condition? So there's room there for the possibility that this definition applies not only to legal ownership, but to what we can call de facto ownership. So that's the first part. The second part is about the powers attaching to the right of ownership. So we're not talking about the powers of ownership, but rather the powers that attach to ownership. And what are these typically? So when we talk about ownership, owning something, a thing, I'm going to hold up you can see a stapler. So I may not own this stapler, but I possess it. As a result, I can use it, I can destroy it, I can sell it, I can do various things with it. But it doesn't mean I own it necessarily. So ownership is understood typically as control. And when it comes to enslavement, it's precisely that. It's the ability for one person to control another as if they own them. And what does that mean? It means control in such a way that the person who is enslaved has no alternative, no choice. So they can be sold, they can be used, they can be destroyed, right? It's left to the other person. And so the Inter-America Court accepted the work that I had been involved with in developing something called the Bellagio-Harvard Guidelines on the legal parameters of slavery that were developed to start a conversation with judges as to how we might interpret it. And in 2016, the Inter-America Court accepted that, in fact, slavery today, you don't have to own somebody, but you have to control them as if you own them. So that's a bit of Slavery 101 about understanding the evolution and why, to some extent, we're seeing a kind of rebirth or refocusing on modern slavery, in part because the law allows for the prosecution to hold a state or a person responsible for enslaving another.
Thank you, Jean. This is really interesting, and it's also very good to hear all of the views from your perspective on international law. I wanted to move then, you mentioned the complexity of defining slavery and its connection to modern slavery. So we wanted to move to Alix now, and forced labor is a part of the wider term of modern slavery. It's been condemned by the international community as a practice similar to but distinct from slavery, and the ILO has been given principal responsibility for abolishing forced or compulsory labor. Looking a few years after the 1926 Slavery Convention, there was the ILO Convention Against Forced Labor, number 29, adopted in 1930. Tell us about this milestone. Why was it significant?
Thank you, Natalie. So in fact, I think the history of the Slavery Convention and the history of the ILO Forced Labor Convention are quite closely linked. Because in the Slavery Convention, in its preamble and one particular article, there's clear references already to the term forced labor. In Article 5 of the Slavery Convention, for example, contracting parties should take all necessary measures to prevent compulsory or forced labor from developing into conditions analogous to slavery in their territories. So there was already this notion, but the focus was very much on state-imposed forced labor and what were, in which exceptional circumstances could you really impose those forms of state-imposed forced labor. So during the process of adopting the Slavery Convention, the Assembly of the League of Nations passed a number of resolutions, and one of them basically requested the International Labour Organization to take over the responsibility for addressing forced labor. And so it took 4 years of negotiations to finally arrive to the adoption of Convention 29 in 1930. And I think, for the ILO and I think for the world, it has a major it had a major impact. First for the ILO, it's the first fundamental convention, how we call it today. We didn't call it that way at the time. But if we look at the history, that's this first convention, if you want, on the human rights of the labor rights, right? So it's very significant. It's important because first it gives for the first time a definition of what forced or compulsory labor is. Which has those two elements of, forced labor being all work or service, which is exacted from a person under the menace of a penalty. So you have really this issue of the penalty, and for which the person has not offered himself, herself voluntarily. So also this notion of involuntariness, no consent to get into this job. At the time, in addition to this definition, so to setting this definition, the convention also added 5 exceptions in which you could not say that this is forced labor. And these were really focused on 5 instances of forced labor imposed by states again. So in fact, if you look at the convention and its adoption, the aim of the convention was to progressively abolish forced labor in colonial territories, while since the start requiring suppression of forced labor for private purposes. So it already established, this, in a way, 2 different aims: immediate suppression of forced labor for private purposes, and progressively abolishing forced labor as a state-imposed form. And this is because also of this distinction that the convention has what we called a transitional period, during which states at the time could still make use of forced labor, but only for public purposes and as an exceptional measure. Today, those what we call transitional measures, of course, have been fully deleted Over the years, in fact, the ILO governing body, the International Labour Conference, and also of our supervisory bodies have acknowledged that those transitional provisions were obviously no longer applicable, but it's only in 2014 when we adopted the Protocol on Forced Labor that they were actually deleted from the convention. So even if they were recognized not applicable, for quite a long time, they stayed in the convention. And I think that's also quite telling. Maybe lastly on the convention, if you look at in the first 20 years of the adoption, after the adoption of the convention in the 30s and 40s, the convention was not ratified by many states. There was not a huge ratification of the convention. Only 19 states have ratified in the 21st years of entry into force of the convention, mostly colonial countries. So it's also putting really the convention into the context at the time. Contrary to today, when we look at the evolution of this convention, which has really evolved and is still what we call up to date, so very relevant in terms of its definition, only 6 countries are yet to ratify it. So it's one of the almost universally ratified instruments.
Incredible. And it's amazing to see how that's evolved definitely over time from 1930 onwards. You briefly mentioned the protocol to the convention, the Forced Labor Convention, which this year we mentioned marks the 10th anniversary. You touched upon the fact that for the protocol, some of these transitional measures were deleted. Why else was this protocol necessary?
That's a very good question. And we have also some elements of response in the historical context, because when Convention 29 was adopted in 1930, forced labor was largely viewed at the time as a colonial phenomenon. And while today, I mean, forms of forced labor have evolved. For example, if you look at our latest global estimates, 80% of forced labor worldwide is imposed by private actors. So you could see that really those forms have evolved, and it also means that we needed not only to tell states you have to prohibit, to criminalize the practice of forced labor, and this is the definition, which was part of Convention 29, but also how, what type of guidance can we give to the international community on how to actually eradicate forced labor in this new era, where forms of forced labor have greatly evolved, and where the bulk of them, happen in different sectors and imposed by private actors. So I think what is quite new with this protocol, and it's a very innovative instrument, is that it's really looking at 3 main sections, we can say. First of all, giving guidance on what should states do to prevent forced labor. And I think that's really the main thing that the protocol brings, because it addresses finally the root causes. Okay, how do you actually tackle the root causes? And the root causes are very much linked to the world of work, to other fundamental rights deficits. So we really needed this guidance. I think before the protocol, I don't think there's an instrument looking at this issue which really gave such details into action on addressing the root causes. For example, looking at how workers are actually recruited. Why do we have so many workers that arrived in debt in their job that forces them to stay? So how can we, for example, prevent recruitment fees and related costs to be collected from workers? How can we promote due diligence of public and private actors? So we have this element of ensuring that both the private sector and the public sector also has a buyer itself and has an employer itself. Has the proper processes in place to actually detect and deal with forced labor when this happens. It also looks, another example, at, for example, the importance of making sure that all workers are covered by labor legislation, because we know that's one of the first vulnerabilities when workers are excluded from labor laws, that then, their rights are not clear, and so you cannot implement also and protect their rights correctly. In addition to prevention, the protocol looks into a focus on how to protect victims of forced labor and how to ensure their access to remedies. So it's a pretty comprehensive instrument that really comes to complement Convention 29. So the definition is reaffirmed, but it only gives, I would say, a modern roadmap on practically how do we step up implementation when it comes to the eradication of forced labor.
Yeah, thank you for sharing. And I think that leads us on to looking now at, we've seen some milestones in our history and how they've evolved in terms of the multilateral efforts to fight slavery. What does that mean today? What has continued? What has perhaps ruptured? Firstly, to you, Jean, the UN has continued multilateral efforts to fight slavery with different legal instruments and bodies, and there's lots that we could talk about there. But in saying that, the world has changed a lot since 1945. We've been through the decolonization process in many respects, globalization, and as we've talked about, slavery and the concept of slavery has also become more complex. Could you share with us your opinion? What have been the main achievements with regard to the continuing work of the League in the UN today?
Yeah, so I think for me, first of all, it's clear that the work that that there's been a continuation of the work of the League of Nations, the 1956 convention. The discussions were already in the 1920s, but the United Nations takes it upon itself in 1956 to establish a supplementary convention which looks at these conventional servitudes of serfdom, of debt bondage, of marriage, and of child exploitation. So already we're seeing an expansion in law within the UN system. And we see also the inclusion of slavery and of servitude and forced labor in human rights instruments and within the UN system, within the International Covenant on Civil and Political Rights, for instance, and also in regards to regional conventions, multilateral conventions. You have the inclusion of slavery, of forced labor and servitude, and also an emergence of business and human rights and a look at supply chains as well. And so there's been a kind of an expansion of at the normative level, but also multilateral, different, let's say, different members of a universal, of a global organizations have been involved. The ILO, as has already been mentioned, was effectively handed over the mandate for forced labor. You have the United Nations Organization on Drugs and Crime that is focused on the criminal elements of trafficking as well. And so you have, and then you have the UN system and its involvement in human rights protection, both charter-based and also with regards to treaty-based mechanisms. So there's been both at the level of institutions and at the level of norms, let's say a mini explosion within the UN of norms and of mechanisms to try to ensure that those norms are respected.
What would you say then are some things that haven't worked or some challenges in continuing the efforts?
Yeah, so specifically to slavery, I think for me, I would have never thought that in this day and age that I thought slavery was at least state-sanctioned slavery was something of the past, but we've seen recently the emergence of legal enslavement within the Islamic State and with regards to the Yazidi women. So that's something for me that's rather incredible, and I think and I hope that justice will come even if it's slow. Also, I think what we've seen for me, so I think that is surprising. The other thing is part of a legacy which comes from what I discussed before of slavery being seen as being legal slavery and states not really acting when from 1948, from the Universal Declaration of Human Rights and through 1966 in the ICCPR, the International Covenant on Civil and Political Rights, that the language changes from abolition to prohibition. And prohibition means that you have to put in place laws to deal with, let's say, to stop people enslaving or to stop people from compelling labor or acting on these servitudes. What that has meant, and this again, it comes from a study that I developed with my partner in crime, Katerina Schwartz, who's at Nottingham University. We developed the anti-slavery in domestic legislation database. We launched it at New York at the UN headquarters in 2020. And what we did was we examined every country, every UN member state, looked at what instruments had they implemented at the international level, so what treaties, but also their domestic law. And quite surprisingly, we found that nearly 50% of all countries in 2020 had not passed any laws dealing with slavery. Now that sounds quite incredible, but for the fact that in the 20th century, states felt that slavery could only be legal slavery, and so there was no reason to pass laws that prohibited legal slavery because they had abolished it. So for me, I think that's one of the legacies and one of the challenges is that, and in the context of forced labor as well and servitude, is that we always have to remind states and push to have states ensure that their international obligations are followed up by domesticating those treaties and bringing it into their domestic law. And I think that's a challenge that remains, and part of it flows from, and I think that's where the next iteration and our discussion will flow on to SDGs and what that may do in assisting in ensuring that exploitation is taken seriously and addressed.
Yeah. Could we focus a little bit more now on trafficking in persons? In the case of the League, they acted as a pioneer to the Convention for the Suppression of Traffic in Persons and the exploitation of the prostitution of others, which was adopted by the UN in 1949. There's also now a special rapporteur on the issue of trafficking in persons. And in 2000, the Convention Against Transnational Organized Crime and its protocols was adopted, which is also considered a landmark in the fight against trafficking in persons. Tell us, what is the connection between slavery and trafficking in persons?
Yeah, it's an interesting question because I'm deep in the midst of writing a monograph looking at the historical evolution of the international anti-trafficking framework. And so quite surprisingly, it seems to me, is that there's little in common. There's little in common in the sense of there's different histories, different frameworks, so a different focus, you could say, that trafficking is very much within the criminal context versus slavery, which is, slavery, which is more of a human rights issue, and a different focus. So for me, there are a number of challenges that flow from it. So very quickly, a different history, as I've mentioned, the history of trafficking is one, it seems to me, and what's been lost, was about trying to address a double standard, a sexual double standard that ultimately was seen 100 years ago, 150 years ago even, as being at the root cause of inequality. That the fact that men bought sex from women meant that there could not be any equality when you commodify a woman's sexuality. And so the pioneers of what is now anti-trafficking at the time, the white slave traffic, was really an attempt by women. It was led by women and mostly, let's say, personified by Josephine Butler of the United Kingdom. And it was an attempt to change society, but to focus on the most vulnerable, and that was children and women who were compelled into prostitution. So a different, let's say, history than the one around the Atlantic slave trade that you've mentioned and the abolitionist movement that ultimately ends slavery as part of an established part of human society. Different frameworks I've already mentioned and different focus. So I think for me, the focus also is interesting because it raises a number of challenges of how we look at trafficking. So one of the ones that for me is quite carries a lot of weight, and that is that there is no supervisory or multilateral supervisory body that looks at trafficking. Rather, the United States of America has taken it upon itself through what it's called its TIP reports, trafficking in persons reports, and US legislation to compel states to carry out certain activities in this area. And so for me, one of the things that makes that distinction is that we don't really have a multilateral framework for ensuring protection of the trafficking convention that you've mentioned. That is the protocol to the transnational organized convention on transnational organized crime. So we've lost that core of the essence of what this framework was meant to be. It was meant to protect women. It was meant to engage with women. And ultimately, at its core, it was meant to change society. It first evolves in 1904 and 1910. You have two white slavery conventions, and those white slave traffic conventions. And those deal really with trying to control the movement of women in the time of steam. So you have, and at the time, colonial ventures, but you have ships and railways, and it's an attempt to control and to stop women from being involved in international prostitution. In 1921, you have a League of Nations convention, and that convention effectively takes those white slave traffic instruments and brings it into the League of Nations. And it focuses not only now on women, but also children rather than girls. So that's an evolution. In 1933, you have a convention that effectively says that what we're focused on is really all prostitution. So if you think about, if you have a law that prohibits children from smoking, and then you expand it to everyone, well, everyone's picked up. It was the same thing with this convention on full age of women. So it wasn't about women being exploited. It was a consensus for that instrument that prostitution itself, international prostitution, should be abolished, should be stopped. 1949, then we get to 1949, and that convention itself in 1949 was a product of the League of Nations. And there you have really the impetus that many had been working for by 1949, almost 100 years, and that was to get states out of the business of prostitution. So the abolishing of state-regulated prostitution. So that you no longer had legal brothels in which the government was involved in ensuring, and really maybe one of the things I haven't said, but I should emphasize that this whole regime was really around to deal with venereal disease. But by the time we have penicillin, then we forget that this whole regime existed. It was about trying to stop, trying to stop venereal disease, but only focusing on women and targeting women when, of course, we know that it takes two to tango. And as a result, especially military was excluded from a regime of which prostitute women were compelled to do, and that was around medical checks and around being detained for a certain period of times, et cetera, et cetera. In 1949, you have this move to stop states being involved in the business of prostitution. it falls a bit to the wayside for a number of years. It becomes very quiet until about the 1980s. So very few states between 1949 and maybe the year 2000, very few states joined that UN convention. In the 1980s, there's a new a movement within the UN, a very strong, compelling movement around the rights of women. And you have a number of international conferences, Beijing, etc., very important conferences. And there's a kind of a groundswell and a push starting within UNESCO and then expanding further to have a new instrument. And that instrument was meant to deal with sexual exploitation, but we get something different out of the Palermo Protocol, out of the 2000 protocol on trafficking in persons. And what we get, which is different, is that we almost lose the essence of this original framework, because not only now is sexual exploitation a part of trafficking, and we don't have a clear definition of what that means. Instead, what we have is leaving it to each state to decide. But maybe more importantly is that you have the introduction of labor exploitation. And so today, a lot of labor exploitation is the emphasis of the Trafficking Convention, and there's very little talk today about dealing with this sexual double standard, which ultimately was at the basis of human trafficking.
Thank you very much for sharing. And it's also very interesting. What I'm hearing also is that we still have a lot to do multilaterally to be able to eradicate trafficking in persons, despite a lot of different work being done over time. Thank you very much, Jean. I wanted to move to you, Alix, to continue on to this conversation. The ILO, as we mentioned, publishes regularly the Global Estimates on Modern Slavery report. 50 million people are living in modern slavery and 28 million in forced labor in particular in that figure. Could you tell us briefly what are some of the root causes which explain these alarming numbers?
Thank you, Natalie. First of all, I think that what is important is also to look at some of the trends of our global estimation, because between the last one in 2016 and the one we did in 2022, there's still been an increase in modern slavery globally. Or at least we see a stagnation, because it might also be explained by improved methodologies and detection. But really not an improvement of the situation, which is a big call for action for all of us to really accelerate progress. And if we want to accelerate progress, we really need to focus on addressing what are the root causes. And they are quite varied depending on the forms of forced labor. So first of all, one, I think, big important information that our latest global estimation gave us is that more than half of all forced labor in the world is occurring in upper middle income or high income countries, which means that it's not only a problem, of poverty and of developing countries. But we really need to look also in those countries, in those high-income countries, how is forced labor still happening today? Another information that allows us to also respond partly to this question is the fact that if we look more deeply at the data, we see that migrant workers especially are 3 times more at risk to be in forced labor situation today than local workers. Does not mean that local workers do not suffer forced labor. In many situations they still do, but migrant workers are more at risks. Why? Because we see that a lot of the root causes of forced labor are linked to unsafe labor migration processes. Again, the fact that workers often still pay a lot of fees for their recruitment, that countries haven't prohibited the collection of recruitment fees from workers in a clear manner, or if they have prohibited, which more and more countries have done in the past 10 years, it's not properly enforced. And we know that's an area which is quite difficult to tackle, but it's possible. When we look at other root causes, in fact, a lot of them are grounded into other fundamental rights at work deficits. So, for example, sectors that are still at higher risk of forced labor are often very informal sectors where workers are not unionized, so they cannot really, exercise their voice. Employment is very informal. There's often a lack of employment contracts, oral offers, oral type of work. We see also a big lack of, social protection systems, with workers, being in situation where they're completely unprotected. And so, having more risk to be deceived into jobs that can lead them to forced labor. Also, lack of enforcement in certain sectors at risk. For example, the ILO is working a lot those days on the fishing sector, which is one of the sector which is, very invisible in terms of enforcement, where workers can be abused while several months at sea. So really looking at those sectors where enforcement is, especially labor inspection and, the monitoring of working conditions, it's very poor. So that's mostly for privately imposed forced labor. And it really allows us to also, create some programs and dedicate most of our action to addressing all those root causes. Now, obviously, if we look at the data, there is still 3.9 million people in situation of state-imposed forced labor. So this requires, and the root causes are very different, obviously, than forced labor imposed in the private sector, because it's mostly linked to still discriminatory legislations or practices, issues of forced labor imposed as means of political coercion or education, or, for example, forced labor has a punishment for holding certain political views. So it's mostly linked to, lack of political will to actually prohibit and change and reform those practices. And I think that in that regard, our supervisory bodies are doing really a lot of work to document, to comment on, to highlight all those root causes and try to really drive this political will, which we really need when it comes to state-imposed forced labor to change the situation.
Yeah. This, I guess, is a good moment to then bring in the SDGs, because you mentioned state-imposed slavery or modern slavery, the private sector as well. The SDGs are looking at a more holistic way that we can end modern slavery. Tell us specifically about SDG 8.7, which is on eradicating forced labor, ending modern slavery, and trafficking in persons.
Thank you, Natalie. So I think what really this SDG has brought is a highlight to the seriousness of those issues, putting really together also those different terms, modern slavery, human trafficking, forced labor, really to the fore with a specific timeline. So it really gave those issues an arena which probably they wouldn't have got, without this SDG target 8.7. So in that sense, I feel that's very positive. It also, in the SDG, there's the inclusion of a specific timeline by 2025 for ending child labor in all its forms, which adds, I think, a sense also of urgency to the target compared to other targets. What is also important from our perspective is that these SDG targets bring together two fundamental rights at work, child labor and forced labor. So not only the worst forms and some of the worst forms of child labor, which are considered forced labor of children, but child labor more generally. And that's important because it means that some of the root causes to address both issues of modern slavery and forced labor and child labor are the same and needs to also be looked at together for action, for common action. Another interesting aspect of the SDG, obviously, is that it is under Goal 8. I think when we hear about the history of certain notions, as Professor Allain highlighted, it's a recognition that those issues nowadays are very much linked to the fact that we do not have decent work. Because Goal 8 is really on decent work and economic growth. So if we want to address those issues, we need to look at them also from the perspective of achieving decent work. We are still on this spectrum where you have modern slavery, trafficking in person, forced labor on one hand, and decent work on the whole other end. And what is needed to respond to those extreme situations is to look at how do we also address decent work deficit, which will lead us to prevent also those issues.
Yeah.
So I think, yeah, in a nutshell, that's what it brought.
Yeah, thank you. We can also cover Alliance 8.7, which is an inclusive multi-stakeholder initiative which aims to bring together governments, UN agencies, regional actors, civil society, workers' organizations to be able to achieve SDG 8.7. It would be nice to hear from you how this alliance works. What kind of impact are we seeing at the national level with regard to the alliance and multilateral efforts?
Thank you, Natalie. So the role of the alliance, after the SDG was launched, the SDG target 8.7, there was really an agreement at the international level that we needed to have coordination if we wanted to achieve this extremely ambitious target. Hence why different partners among governments, workers, employers, civil society, academia came together, and 1 year later the alliance was created and launched. And I think the main objective, which still remains today after the first years of operation of the alliance, is to first try to better coordinate efforts, more effectively share promising practices of progress, showcase those practices so that it can also influence and inspire in other contexts. Also benefit from technical expertise from the partners inside the alliance. So nowadays there's more than 395, I think, partners, which shows you really the level of variety also of the partners. Now I think that the alliance realized over the years that one essential component of it is really to have much more impact at the national level. Of course, global work is important. It's key for advocacy. But if progress is not happening at the national level, you can continue to advocate, there will be zero progress. So hence why they created this strategy of what we call pathfinder countries. So the objective is really to motivate countries to go faster on the eradication of forced labor by really engaging themselves with so today, for example, there are 27 Pathfinder countries around the world. And to become a Pathfinder countries, you have basically to organize at the national level across all different actors a strategic planning workshop to really put together a roadmap on how you're as a country you're going to plan the eradication of forced labor and on the different aspects. And then much more recently, there's an element that has been added to the Pathfinder country strategy, which is that countries have to report on progress every year. And there will be also a monitoring working group that will really review all the progress of those Pathfinder countries to give this process also much more credibility. Because the idea is really to make sure that those countries are actually leading the way and making progress. So that's the Pathfinder country strategy is the main vehicle to really push, accelerate the work at the national level. And then the Alliance has also other means of actions, including action groups, for example, on specific issues like addressing forced labor, human trafficking, modern slavery in supply chains, the specific issue of labor migration and how to address challenges linked to migrant workers in situation of trafficking and forced labor. But these are more a group at the global level where partners comes and agree also on a work plan and then work together to achieve those goals.
Yeah, thank you for sharing, because I think it's important for us to understand that when we have a goal and it is an ambitious goal, how do we make it happen? And the enormous amount of work that's happening at the national level to see that happen. Thank you for sharing. Jean, you are also a member of the reference group for the Alliance 8.7 Knowledge Platform. So coming from your background in international law, we wanted to ask you, what do you think about SDG 8 and particularly Target 8.7, and how can a legal response as well as this approach through the SDGs work together to really see an eradication of modern slavery?
Yes, thank you, Natalie. I think Alix has covered a lot of the material. I think the perspective that I see, that the SDG 8.7 gives us that opportunity to focus and for various stakeholders to come together. And I think that's one of the very important elements of it. I think also, if I can say that one of the challenges in this area is that you have what seems to be a multilateral, you have various parts of the UN system or the larger UN family that are involved in dealing with different elements of exploitation, and that needs to be coordinated. And so 8.7 does not necessarily at the multilateral, at the institutional or organizational level, but it brings people together. And I think hopefully we can build on that momentum to so that we don't get into situations where the whole system isn't rowing in the same direction. Now, when it comes to legal responses, I think for me, what Alix has emphasized, and I think is very important, is ultimately that legislation has to be found in the domestic order, and it has to be enforced. And that, to me, it's around enforcement. One of, I think, probably the most important things that is driving the UN human rights system, and more generally when it comes to protecting people, whether it's human rights or labor rights, is a shift from standard setting to remedies, to looking at. So it's one thing to write something, to say we are all free from forced labor, but it's another thing to ensure that that norm is respected and that ultimately there's a remedy when there's a violation. And I think that for me is very important. It's fundamental. Obviously, for me, I think also is that when we're talking about domestic legislation, where does that flow from? And that's decent work and the ILO labor standards. If we were, and if countries were really invested in ensuring that those standards were being upheld, then we probably wouldn't be meeting right now to discuss issues of slavery and forced labor. So fundamental. And I see also that, again, business, human rights, criminal law, labor law, there are various ways to attack this beast of exploitation, but to recognize, and Alix has mentioned it, that really what we're talking about is exploitation in the workplace. exploiting people's labor. One of the challenges that we continue to have is around migration, and it's been mentioned already, migration. And how do you seek to balance migration versus exploitation? And states generally are more inclined to want to reinforce borders than necessarily seeking to ensure that workers' rights are being respected, or that the law is applicable to everyone within the jurisdiction. That for me, I think, is where the SDGs, some of the challenges, but also some of the positives to emerge, and hopefully, clearly very ambitious, maybe a bit contradictory in the sense of talking about children's rights on the one hand, and then looking at worse forms of child labor, setting a very ambitious target. Now we're a year away, really 2 years away, but a year away from dealing with child labor. And what does that mean going past that? If we've missed that target, what does it mean into the future? And I think that's a challenge for all the SDGs, really, is how do we keep momentum? But it's clear the SDGs have created new coalitions, have created new ways of thinking about multilateralism that goes beyond a state-centric, bringing in different actors. And I think that's very exciting. I think it's new territory, and it's making for a need for everyone to start to understand and how they can work together. For me, it's an exciting time, and for exploitation itself to be at the focus of an SDG is very important to ensuring that we're not losing sight of the fact that there are many people on this little planet of ours that are taken advantage of. Their labor in the main is being taken advantage of, and how can we make for a decent working environment and a better world?
Absolutely. Thank you so much for sharing. And the question around inclusive and accountable multilateralism is something we're all discussing today, especially here at the United Nations. Let's bring in Marie and Jan now. Our students who we mentioned joined us at the Library and Archives for a research project. Marie, could I ask you to share a little bit more about the ARP, or the Applied Research Project? What did you do, and what was the outcome of the project?
Hi, yeah, thank you very much for this question. So Jan and I, as part of our curriculum, our master studies, we engaged in an applied research project where student groups conduct research with international organizations in Geneva mostly. And Jan and I worked with the United Nations Library and Archives for a period of 4 months in the spring of 2023, so basically a year ago. And the product of our research was an internal report for the United Nations Library and Archives, in which we examined the historical role international organizations played in dealing with slavery on a global level. And yeah, what we did was examining many documents and primary sources, such as conventions and the protocols the colleagues you just talked about. And also, we looked at secondary sources and secondary literature, and conducted a few expert interviews to enrich our analysis. And the main takeaway of this report was that international organizations are indeed essential actors in setting global standards and providing also places for various actors to discuss the issue of slavery. And what we liked most about the project was also visiting the beautiful library full of important historical documents and learning about the deep and complex history of international organizations.
Yeah, and we invited you to share a bit about the project, but also you mentioned the fact that you can access the archives here. We have presented you the challenge of just choosing 3 that inspired you, that you wanted to share with our speakers, but also our audience. So over to you, Jan, to start with the first document. What did you choose?
I think I'm starting with the 1926 Slavery Convention. And yeah, we already discussed during the course of this recording that the Slavery Convention of 1926 is truly an important document in the fight against slavery, and therefore it was also the starting point of our research. And since the founding, the League of Nations was concerned with slavery and the slave trade, and the slavery of Convention of 1926 was kind of like the first international treaty banning slavery and the slave trade within the League of Nations. And what stood out of us was that the convention allowed for like a broad conceptualization of slavery and similar practices. And yeah, what we found very impressive is that the definition remains even like relevant until today, almost 100 years later. And it is also very interesting to see that slavery was kind of like considered the first international human rights issue.
Thank you, Marie. And we have talked about this convention from the beginning of the conversation. It's really nice to see the document itself and how, you know, it connects to our realities. Thank you, Marie. And so, Jan, over to you now. You're going to share with us the two other documents.
Yeah, and continue for the second document. It is related to the International Convention for the Suppression of the Traffic in Women and Children, which was adopted under the auspices of the League of Nations in 1921. And it is interesting because we find it shows the International Association of their assistance to the League, and it also demonstrates the interaction between this association and the bodies created by the League, and to fight against the trafficking of women and children. We also find it significant because it shows how multilateralism can work better for the common concern. And the memorandum of the International Association for the Protection of Childhood also shows how they help to collect and supply information, as well as undertake unofficial negotiation in different countries. And in some cases, private institutions also act as an intermediary and further extend the multilateral action of protecting women and children of all races from exploitation and abuse. And for the third archive, it is the first page of the records of the International Labour Conference that adopted the Convention of Forced Labour in 1930. The record shows the apprehension were expressed during the debate, questions of compulsory military service were discussed, and the objections were explained. Also by French, by British, by Portuguese, various government delegates contribute to the adoption of the articles. And it shows the roles of the workers' group in the drafting process of the convention. We find this article interesting because it shows the action of the International Labour Organization, and it is crucial roles in promoting labor standards and social justice, which elaborates on the importance of multilateralism in this international concern.
Yeah, and these are incredible documents. I think it's nice to see not just the final results and the conventions, but the working documents, and being able to access them now helps us to really understand, you know, how complex multilateral efforts are. Thank you so much to you both for selecting these documents. Marie, I'm going to head back to you because you have the final question to both of our speakers.
Yes, the final question to you today, even though you already explained a lot to us, is, I mean, as we can see, multilateralism and international cooperation are key elements to eradicating modern slavery, forced labor, trafficking in persons, and child labor. In just 1 minute, like, what is the main priority today to achieve this goal? Maybe Alix, you want to start?
Thank you very much for this question. I think that if we reflect on our discussions today, so some of the major improvements and the impetus really in this fight against slavery, forced labor, is really anchored into the multilateral system, especially with the adoption of those landmarked conventions and protocol. But I feel that today, what we really need to do, and as we celebrate in 2024 the 10 years of adoption of the Forced Labor Protocol 29, is really to accelerate progress on how do we actually support implementation of those instruments. The focus should really be on implementation at the national level, and looking, of course, at regional and global level, what is the type of advocacy, of research that is still needed to continue putting this issue at the top of political agendas of the different countries in the world. So it's obviously a joint work, but with a major focus on supporting governments, workers, employers, civil society, other actors really implement those provisions in the different countries. I think that's only like this that we will actually accelerate progress and tend towards getting nearer and nearer to the SDG target 8.7. Thank you.
Marie, if I may, from my side, I would say, you know, in one sentence is what Alix was referring to, and that's getting states to take labor law seriously and to act. And you know, in many ways, I think business has and corporations have for a long time had a bit of a free ride, and it's important on them in regards to their social responsibility, and that we start emphasizing the role of business as being fundamental to ensuring that states are respecting the rights of workers. And then, of course, for me, the thing that I'm most interested is the multilateral framework and ensuring that the various elements of the UN that deal with exploitation are working together, see a purpose, and to some extent the SDG has given that a purpose that goes beyond any one institution. And I think that's a very positive thing. As I've mentioned previously, what happens after the SDGs and whether we can keep that momentum going and keeping what is, I think, a very good marketing tool in ensuring that that exploitation stays at the forefront of the global consciousness, not only of states, but of businesses and society, civil society, and society itself. So I think states taking labor laws seriously and the multilateral system working on all gears.
Thank you very much. There is so much more we could talk about, but I think that's a very good way to end. Professor Jean-Allain, Alix, Nasri, Marie Oy, and Yan Zhu, thank you so much for joining us today to look at the evolution of efforts in multilateralism to fight slavery. There's still a lot to be done, and so we keep going to work for the SDGs and beyond. We hope that you enjoyed this conversation, and to our audience, we hope that you learned and enjoyed being with us for this latest Histories. If you'd like to consult the documents that Marie and Yan shared, we have our UN Archives Geneva platform where you'll be able to find them on the screen. We'll also put it in the YouTube notes for you to access. You can also ask an archivist here at the Library and Archives if you have any questions on today's episode or other documents you'd like to consult. You can also find all of our Histories episodes here on our YouTube channel at the Library and Archives. Again, thank you for joining us, and we hope to see you soon for the next Histories. Until then, take care and bye for now.